Okay, welcome to this fourth session of the day, right before we have the coffee break. Contrary to what is indicated in your schedule, my name is not Professor Inger Johanne Sand. I would be able to pronounce it better if it were. My name is Mieke Olertsen from the University of Maastricht, and I'm the replacer for Professor Inger Johanne Sand because she cannot be here today, unfortunately, due to an illness. So I will take her place for now. We have talked already in the previous sessions a lot about shareholders versus directors, shareholders and directors. We have talked a lot about shareholder primacy and how we can turn that around. Now we're going to dedicate our attention to other very important value creators within the company, and next to the capital, we should not forget the factor of labor as an important value creator. Therefore, this session is dedicated to reforms proposal in the areas of the lessons that can be learned from labor-centered corporate governance and social entrepreneurship. And our first speaker is Professor Lorraine Talbot, who is going to talk about the UK perspective on how we can operationalize sustainability in corporate law reform through a labor-centered corporate governance. Thank you very much.
Thank you very much. Okay, this is a fraction of the paper that was posted. So in fact, I'm going to be concentrating on the problem of law reform in terms of how it is perceived and utilised by the users, because it's not always predictable in terms of how the effects that it will make. Users will quite often bypass law reform and find different ways of manipulating it. And so the outcome can be quite undesirable. So, because we haven't talked about Section 172 quite enough, I thought I'd take you through it again, but perhaps with a different perspective. So the first column here is Section 172 as it stands, the purpose of the company, and I think this does direct to the purpose of the company, and I somewhat differ from Andrew et al.'s analysis here, because I think this does tell us about what the company is designed to do. And I think the way that it looks at the minute is because of the strength of ideology at the time that the law was being reformed and the impact of neoliberalism on that law reform process. So what we end up with is actually something that is mandating shareholder primacy, I would argue. What we can see here is that the director must act to promote the success of the company for the benefit of members as a whole. That's the motivation is for members as a whole. And in so doing so, have regard to, and there's a list, A to F, and of course, you can add to that list as has been mentioned. So other factors will be taken account of insofar as they promote the benefit of members as a whole. So you could add anything to that list. You could add bunnies or fluffy kittens. You can add that to it, and directors can say, well, we considered the fluffy kittens, but I'm afraid they weren't going to promote the company in the interest of members, so we had to decide not to do that. We'll report on it, we'll justify our decision, but the fluffy kittens they're out. Now, another way of reforming this particular section, and one that is, I think, quite popular, is to take out for the benefit of members as a whole. And so you just have a sort of neutral list of all individuals that are taken account of. And this is very much a sort of stakeholder approach where you just have this list. Now, the problem of this kind of list is, as has been noted by many speakers today, is that you have so many other important imperatives on director activities, such as the equities market, such as the dreadful entry into shareholder-orientated governance, where we're actually putting the lunatics in charge of the asylum as a good corporate governance approach. So this will be entirely tainted by the context in which it would operate. Alternatively, if we reconstructed this section to replace members with employees, so we say that the success of the company is posited on the benefit of the members as a whole, and in so doing have regard. This is an incredibly shocking construction. It's a construction that obviously we'd never see unless there was an entirely different political environment, but it's one that I think really brings out the purpose of the company. It's so shocking to think that a company could be orientated for the benefit of its employees and have regard to all the others, including fluffy bunnies. Because companies simply do not operate for the interests of employees. They operate for the interests of shareholders, and they're there to produce value for shareholders. And employees are utilized in order to promote value for shareholders, not the other way around. That's not what companies are about. So it's a very shocking reconstruction, but I think it's quite an important reconstruction because it would really deconstruct what a company is actually about. It changes the whole nature of the company once you put it in that format. And it also gives you an idea of the scale of the reform that is required to make really important and radical change. Now, while I want to look at how companies actually do operate in the interest of shareholders and utilising labour for this end, by looking at the example of multinational companies and the different strategies that they use. So extracting value through labour. Multinational companies can work broadly on two models. Investors making profit at the other end through production, which operates through a parent subsidiary model. So here we've got the extraction industries, that's asbestosis mining. On the other hand, you've got an outsourcing model, which can be outsourced to companies that are even bigger than the company that is doing the outsourcing, as in Apple and Foxconn, where a single factory in China has 10 times more employees than all the American employees in Apple. Or alternatively, you've got a slightly smaller scale operation in the garment industry. Now, whether a company will choose to go for the outsourcing or insourcing subsidiary model is understood by Coase and current modern transaction cost theorists as being a decision based on the transaction costs involved in operating in the market, bringing things in-house because that reduces transaction costs. However, I think there's a different way of looking at that kind of theory and saying, actually, labour is brought in-house because companies more successfully extract value from labour within the corporate form rather than within the market. It reduces their independence and it maximises labour productivity. And William Lazanik is very interesting in this when he looks at the 19th century putting out system, which, despite its high capital costs, was much more efficient when bought in-house, when people were taken out from the home working at home and bought into a factory system. Now, a lot of labour resistance to that, no one wanted to do that, but the high capital costs were highly offset by the benefits of being able to bring labour in and extract as much value as possible. So two mechanisms for extracting value today. Modern transaction cost theories. Some argue that it only works for low-skilled labour, such as the garment industry, that there's too many transaction costs for it to work in a high-tech industry. But more recent stuff saying that modern corporations are innovative, they're restructuring, their core knowledge is becoming increasingly more centralized. They're able to fragment knowledge, and so in this way they're able to use higher tech, outsourced to higher tech parts of the production process. And this is particularly important given that outside the elite educational institutions in the United States and the UK, educational achievements below that are significantly higher in this generation than they were in the previous generation, whereas one would hope it would be going the other way. Now, alternatively, value can be extracted by close management through parent and subsidiary companies. So Thor Chemicals, which was a company in Margate in Kent, England, couldn't operate in Kent because of the high levels of mercury that its workers were consuming. And so they were closed down, and they picked up and they went to South Africa during the apartheid system. They took a lot of mercury products to recycle, and they also recycled their employees as well. The solicitor for the case here shows that they used to allow people to work up until their mercury levels were too high, and then they would get the sack and they'd bring a next lot of persons in. Now, operating in this way was highly profitable. Utilizing labor in this way was highly profitable. But we've had two things that have happened at the level of law which may make that less profitable. First, it's not possible to delay the legal process anymore through the doctrine of foreign non-convenience, which is a common law doctrine which allows the parent company to say the action should be heard within where the harm was caused and not in our company, not in our jurisdiction. And a recent decision, Chandler and Cape, where the parent company was found to owe a duty of care to an employee of one of its subsidiaries. So being able to sidestep the negative externalities of operating in this way, that was always protected through veil, for not being able to pierce the veil, are slightly more fragile now, possibly. And in that context, it may be better for companies to be able to outsource, that it may simply be cheaper to extract value through the outsourcing model rather than through the closely managed model. But either way, company success is posited on finding new and innovative ways to extract the maximum value from labor. And so company law for reform, whilst it might be necessary, whilst it might signpost a direction, companies will always be able to slip out from that if it's just company reform per se. It will still seek to try and meet its primary objective, and which I argue is extraction of value for shareholders. So in order to make those reforms effective, a lot of things would have to be done. The first thing to do is get rid of shareholder stewardship, which is a disaster, and all other shareholder-driven form of governance, and all ways in which shareholders can affect or grab the director's attention by having so many voting powers within the company. And then, as I say, there's the long list, and some of that long list is many of the things that have been discussed today, still to be done. Thanks very much.